Hello everyone and welcome to this video tutorial in which we're going to do some A-level law revision on the Occupiers Liability Act 1957. And if you're familiar with Occupiers Liability, which hopefully you are, you'll know that there's two acts of Parliament that you need to know about for the exam. So we've got the Occupiers Liability Act 1957, which we're going to be looking at in this video. And there's also the Occupiers Liability Act 1984, which I will do a separate video on, which deals with trespasses. Both the Occupiers Liability Acts of 1957 and 1984 impose an obligation on occupiers rather than landowners in respect of injuries and damage that occurs when somebody comes onto someone's land. The law on occupiers liability quite frequently comes up on scenario type questions where you need to advise certain characters whether they're going to be liable under the Occupiers Liability Act, and it can be a little bit complicated. So for this revision video I've got a flow chart here which I'm going to talk you through, which hopefully will really help you to understand the different rules that you need to apply to determine whether your claimant is going to be able to sue the defendant successfully under the Occupiers Liability Act 1957. So the first issue you need to determine is whether or not you've got an occupier. Now, occupier is defined under section 1.2 of the Occupiers Liability Act 1957, but somewhat frustratingly, the definition is just saying that the common law definition applies. Would have been helpful if they'd actually included the definition in the Act, but they haven't. They've referred us to the common law. So you need to know the case of Wheat and Lacon here, and this is a case from 1966 in which Lord Denning defined what an occupier is. And Denning held that the question of whether a particular person is an occupier or not is a question of fact, and it depends on the degree of control that they have over the property. So it's called the occupational control test, and there can be more than one occupier of the same premises. So once we've determined that we've got an occupier, the next issue we have to look at is whether there are premises. And by virtue of section 1.3a of the 1957 Act, the Act not only applies to land and buildings, but it also extends to fixed and movable structures, including any vessel, vehicle or aircraft. So if your claimant has been injured on any of these things, then potentially you've got liability under the 57 Act. So once we've got an occupier, and we've got premises, we then need to consider what the common duty of care is owed to our claimant. And as you can see, the common duty of care is set out under section 2, subsection 2, and it says the common duty of care is to take such care as in all the circumstances of the case is reasonable, to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. So we've got that word that we so often see in law, that we've got to ensure that the person is reasonably safe for the purposes that they are entitled to be there for. And what is reasonably safe is going to vary depending on the type of visitor that you have. And that's why you can see on this flow chart here that the common duty of care is going to vary slightly. And so we need to consider whether there are children, professional persons, whether any warning signs have been given, and whether we've got any independent contractors. And a little tip for you, quite often in exams, you're going to see children, you're going to see warning signs, and quite often there's some work done by an independent contractor as well. So you do need to make sure that you're aware of these different situations. So if a child is injured on property, we need to consider section 2.3a of the 1957 Act. And this section of the Act says that an occupier must be prepared for children to be less careful than adults. And it's useful to look at some cases here. So in Phipps and Rochester, we had a 5-year-old boy walking across some open ground with his 7-year-old sister, and there wasn't an adult with him, and he was injured when he fell into a trench. Now, the defendants that owned the land were not held liable because the judge said that an occupier is entitled to assume that prudent parents would not allow such a young child to go unaccompanied to places where it's unsafe. So you're going to need to look out as to whether the child is so young that you think a parent or a responsible adult should be in charge of them. But it's useful to compare the case of Phipps with the case of Jolly and Sutton. And Jolly and Sutton, if you remember, is where we had two teenage boys who were injured when they were playing on a dilapidated old boat that had been left derelict on some council land. Now, in contrast to Phipps, in this case, the council were liable for the injuries to the children on their land because the type of accident and injury which occurred was reasonably foreseeable, because the children were injured when they were playing on the boat, and it's reasonably foreseeable that a boat is going to be an allurement to children. Children are going to come and meddle with it, and the council had a duty to remove that so that injury did not happen. So we've dealt with children then. Let's consider professional persons, and this is sometimes referred to as someone exercising their common calling. And this is under section 2.3b of the 1957 Act, and this provision applies where an occupier employs an expert to come onto the premises to undertake work. Now, be very careful here because students often get mixed up between this section and the section relating to independent contractors. So the difference here is that with this professional person section, we are looking at this if we've employed a tradesperson and they get injured themselves completing the work. Whereas when we're looking at independent contractors, this is where an independent contractor is hired to do some work on the land, and then somebody else, i.e. a third party, is injured by the work of the independent contractors. So there's a difference there. So make sure in the scenario you're looking at, was it a tradesperson who injured themselves carrying out their job? Or was it an independent contractor who completed work when someone else was injured? So back to the professional persons provision under 2.3b then. This provision, as I've said, applies where an occupier employs an expert to come onto the premises to undertake work. And the rule is here that the expert can be taken to know and to safeguard themselves against any dangers that are ordinarily associated with their job. So for an example, if an electrician is employed to do some work on electrics at the house and they get electrocuted, then that's likely not to be the occupier's fault, because an electrician should guard against the risks that are ordinary to dealing with electricity. However, if an electrician came to the house and was injured because they fell down a hole, then arguably the occupier would be liable, because falling down holes should not be a risk ordinarily associated with being an electrician. So the classic case here of Rolls and Nathan is where we had two brothers who were chimney sweeps who were cleaning the flues in the occupier's home. And the flues of the chimneys were dangerous due to carbon monoxide poisoning, and unfortunately the chimney sweeps were poisoned. Our defendant occupier was not liable in this case because the dangers of carbon monoxide poisoning was sort of a normal risk of dealing with chimneys, and therefore our chimney sweeps should have guarded against that ordinary risk. We always contrast the case of Rolls and Nathan with Ogwo and Taylor, because Rolls and Nathan doesn't create an absolute rule, because in the case of Ogwo, a firefighter was able to recover damages when putting out a fire at the occupier's premises, because the court held that there was no such principle which prevented firemen from claiming damages for injuries which they incurred whilst fighting a fire that had been negligently started. So it's always going to depend on the facts of your case. Let's move on then and consider warnings under section 2.4a, because it may be possible for an occupier to discharge their duty by giving a warning of the danger. However, this section provides that a warning given to the visitor won't be treated as absolving the occupier of all liability unless in all of the circumstances it was enough to enable the visitor to be reasonably safe. So it comes back to that section 2.2. The warning must allow the visitor to be reasonably safe. It's useful to use the case of Derby and National Trust here. And in this case, Mr. Derby drowned in a pond that was owned by the National Trust. So the National Trust were the claimants. But there was no liability here because it was held that the risk to swimmers in the pond were perfectly obvious. So it gives us the principle that there's no duty to warn of an obvious risk. And let's just look at the last situation here, dangers arising from actions which are undertaken by independent contractors under section 2.4b. And this provision says that an occupier is not liable for dangers created by independent contractors if the occupier acted reasonably in all the circumstances in entrusting the work to the independent contractor, and they took reasonable steps to satisfy himself that the work was carried out properly and the contractor was competent. And it's always useful to compare and contrast the case of Hazeldine and Dorr and Woodward and the Mayor of Hastings. So Hazeldine and Dorr was an unfortunate case where the claimant fell down a faulty lift shaft after independent contractors had done faulty work there. And in that case it was held that the occupier was not responsible for the work done by the independent contractors because the work on the lift was so technical an occupier couldn't be expected to check it. However, in Woodward and Mayor of Hastings, the occupier had employed an independent contractor to clean up some snow from some steps. And when the claimant was injured on these steps, it was held that the occupier was liable because it isn't technical to check whether snow has been moved off a step or not. It's quite easily visible for anyone to see. It's not a technical matter. So the occupier should have checked that that work was done. So in your scenario, it's always going to come down to whether it was possible for the work to be checked and whether the occupier took reasonable steps to make sure that the independent contractor appeared to be competent to do the work. Okay, so that's our whistle-stop tour of the Occupiers Liability Act 1957. I hope you found that bit of revision really helpful for your exams.